First of all, good morning, everyone. My name is Carmen. Thank you so much for joining us for this very important webinar today. First of all, I'd like to extend our heartfelt thank you to Withers Hong Kong, and especially to Anisha Ramanathan, partner from their family law team, for taking the time to guide us through this very critical topic. Now, life planning is undoubtedly a serious and perhaps somewhat even morbid subject for many parents. But the decisions we make today will have lasting impact on our children's futures. So hopefully the session will provide you with a glimpse of the considerations involved. Now, with only 1 hour allocated for this webinar, Anisha has thoughtfully prepared to address some of the primary concerns that many parents have sent us. Please feel free to reach out to Anisha and her team afterwards for further guidance. Now, I'd like to take this moment to thank our co-organizers, the Harbour School, particularly Chloe from the PIP program, Eve and Dr. Amber over at the Children's Institute. Your collaboration and support have been invaluable in bringing this session to life. So without further ado, I will now pass everything to Anisha. Thank you so much for leading us through today's session.
Welcome to the Optism channel, where we journey with Carmen to raise autism awareness and move steps closer to inclusivity. Join us as we meet community members, share stories, and explore initiatives that make a real difference.
Thanks very much, Carmen, for that lovely introduction. Good morning, everyone. As Carmen mentioned, we just have the hour. This is actually quite a huge topic, but I'll do my best to cover as much as I can in the limited time I have. So this is briefly my bio. I am a partner in the divorce and family team at Withers. My practice predominantly relates to all matters concerning family law, divorces, children issues on custody, care and control, and access. We have seen the trend in a lot of the family work that we do where neurodiversity is a highlight, it's a feature, and that has impacted the way that we see and handle family cases in the family court. Now, just briefly, looking at special considerations for SEN families. Common sense conditions, I'm sure some of you might be aware, are autism, spectrum disorder, attention deficit or hyperactivity disorder, dyslexia. And we see an increase of these type of conditions, especially after COVID-19 in Hong Kong. Every child is unique, especially for SEN children. That's something that all parents need to be aware of. For children with SENs, safeguarding their continued access to specialized support and accustomed routines and established educational programs should really be the guiding tenet. Consistency and stability are paramount for their optimal development and emotional well-being. So the purpose of the seminar today is parents are here today to be able to look after the emotional well-being, physical well-being of the children. But what happens when you're not around? You want to make sure that stability for them continues. Should there be any unexpected circumstances, efforts really need to be made to minimize disruption to a child's life as much as possible so that they continue to thrive in their adulthood. So for families with children who have learning difficulties, disabilities or differences, or other neurological conditions such as ADHD, tailored strategies really are essential. Neurodivergent children thrive in their environments that offer structure and predictability. So parents are encouraged to remember the principle, don't use the mind to solve the mind. Rather than expecting immediate self-correction, children benefit from external support systems and compassionate guidance. So in terms of looking at the well-being, emotional and social well-being really plays a crucial role when it comes to supporting children with SEN. Parents at times may feel overwhelmed and don't know where to start. So it's important to build that strong network where you engage with other families, therapists, support groups, where they can provide valuable insights and encouragement. Thriving families rely on proactive strategies that encourage mutual respect, responsibility, and external support where needed. By staying in touch, you know you're not alone and that there are many resources and access to services that are available to you. But more than anything, the research has shown that raising a child with SEN can be 3 times more expensive than raising a child without SEN. So proper financial planning really is essential. So overall, you need to understand the needs of your children and their specific concerns. Communicate those with your lawyers if you are taking the next step for financial planning. Make tailor-made plans, i.e., whether you need a will, whether you need to have guardianship documents in place, or perhaps even an enduring power of attorney. So these are some of the topics we will be exploring in the session today. I'm sure most of you are familiar with a will, have definitely heard of it. It might have come up in conversations with family and friends. It is definitely a topic that comes up, but whether you actually proactively take steps to put it in place. It's a legal document by which a person sets out his or her wishes as to how his or her assets are to be handled or distributed upon his or her death. Now, why do you need a will? There are a myriad of reasons for this. How do you want to provide for your family? We've all worked hard, we've built our assets. You want to know where your assets are going to go. Who should be the ones taking care of your children? How old do you want your children to be when they inherit from your estate? Who will deal with your estate on your passing? Should an asset be sold or should it pass on to future generations? It gives you the testamentary capacity to be able to handle your financial affairs, and you can plan for how your affairs to be dealt with once you've passed. What about business assets, companies, investments, stocks, shares? What about your assets outside of Hong Kong? Who should benefit in the event of a family disaster? One of the main reasons is because you do want to avoid intestacy. Intestacy happens when you do not have a will in place. And by default, without having a will to go to probate, there's a loss of control. And whomever is the person who reports the death, they will not have immediate control over how your assets are going to be dealt with because they may not be a beneficiary. You have not appointed them to receive your assets. So they cannot give effect to your wishes. And automatically the intestate estates ordinance would fall into place. And the intestacy laws in Hong Kong would come into effect. So without a will, this is what the scenario may look like. If you do have a surviving spouse, but you don't have any children, and you do have parents and siblings, no children, no parents, no siblings, your surviving spouse would receive 100% of your estate. But it's not as straightforward as your will being probated and then your surviving spouse receiving the remaining assets as you wished. A process would need to be complied with, and it takes time. Now, it could be, what if the surviving spouse is someone who's been financially dependent on you? He or she would need to wait a significant amount of time to then be able to receive your assets. If you pass and you do have a spouse as well as children, the intestacy laws basically say that all your personal chattels, your spouse will receive those and $500,000 Hong Kong dollars with some interest, and half of the remaining assets are your estate, with the remaining half automatically going to your children. So that's out of your control. I mean, what if you have a child who's a minor? The half residue won't be given until the adult child attains the age of 18. That is still a very young age to receive half of someone's estate. And if it's a significantly large estate, whether you trust your child at the age of 18 to be receiving and how they're going to handle that money. If you pass away, you do have spouse and parents, but no children, then you can see in the table how your estate will be divided. It's slightly higher amount, but then your surviving parents would also receive from your estate. If you for example, do not have a good relationship with your parents and never intend for them to benefit from your estate, again, that's out of your hands. The intestacy laws provide that they should receive. And then there's also the scenario that if you don't have any surviving spouse, that you do have children, they would receive at the age of 18. And if you have one child, they would receive the entire estate. If you have more than one child, it would be in equal shares. If you don't have any surviving spouse, you don't have children, your parents will receive your full estate. If they are not surviving, it would go to your grandparents. If they don't survive, it goes to your uncle and aunts. And if they don't survive, it goes to the Hong Kong government. So, just something to think about. And if you have a will, of course, this overrides this entire table because you can dictate how you want your assets to be divided. Just do keep in mind that a partner or a cohabitee or friends do not have any rights under intestacy laws in Hong Kong. So we went through why you want to avoid intestacy. You don't have any control who will be managing your estates. We covered how under intestacy laws, your assets are going to fall into the various categories. You don't have control who will take care of the welfare of your minor children. And that's really important because the government will be dealing with, or whoever puts it towards the intestacy under the ordinance, they will not be dealing with guardianship unless any formal applications are made for your minor children. If you do have surviving spouse, of course, by default, they would have the custodial rights. What happens if both of you pass? So you would want to record your wishes in a deed of guardianship at the very least. So part of that also is you want to make use of some planning opportunities where there are multi-jurisdictional elements. So intestacy laws in Hong Kong would deal with the assets here in Hong Kong. And any overseas assets may not come into play. So that's also something that's a significant, if you do have investments or properties overseas, something to consider again. So looking at the advantages of why you would want to have a will, it gives you testamentary freedom, as I mentioned. If you co-own a property in Hong Kong by way of a joint tenancy, that would fall outside the will, where by default, if you pass away, the joint tenancy allows a surviving spouse to continue to have ownership. Insurance policies usually don't fall under a will. If you pass away with a death certificate, you would show that to the insurance company and they would issue a check to the beneficiary under the policy. Usually the insurance money is the first amount of money that gets paid out to a surviving spouse. So there could be challenges to the validity of the will. So it's very important that a will is executed properly, that you comply with the requirements of signing a will. You get to choose your choice of personnel. You get to appoint who you want to be the executor of your will, whether you choose that person to be a lawyer, a trusted family friend, a family member, or a professional, could be a law firm. And then within that, you could also state who the permanent guardians of your minor children are going to be. Often the case in Hong Kong, being a very international city, often permanent guardians reside out of Hong Kong. So you do want to make sure who are going to be the interim guardians here in Hong Kong until the permanent guardians can come and collect your children. And this applies for children, whether they're with SEN or without, because, and that's where, especially if you do have a child with SEN, that person that you appoint to be the guardian has to be someone you trust, has to be someone, or preferably somebody that your child knows and is familiar with and will be comfortable with. And then, of course, in your will, you have the option to make any specific gifts. And you would take into account, of course, tax planning purposes. If you own property or assets in the US or the UK, there could be major tax implications, especially with the recent changes that have been going around in both those jurisdictions. So aside from that, and specific gifts and how you want your assets to be divided, the leftover of your estate, anything that's not specifically mentioned in your will, is what is referred to as the gift of residue. Now, usually you would gift that to more than one person, and you would consider a few things. You would consider each person's share in percentages. How would you want that divided? If you have more than one child, would one child need more in terms of allocation than another? Are there any medical issues, or would the cost of living for that child be more? And so you want to take provision of that. There could be absolute or contingent gifts at certain ages, particularly when people are doing their wills when their children are quite young. You would want to stage for them to receive their money. It could be a smaller portion at the age of 18. It could be another 3 years at the age of 21 and then 25, but they receive their full inheritance at the age of 30. So you can dictate at what age you would like your children or the beneficiaries to receive your monies. So perhaps I can give one example. What if you want to leave your apartment to your nephew, who's a minor, in your will? Would he be able to hold it in his name? Would you have to appoint a trustee to hold it in trust for him until he's 18? Is it a must or just customary to appoint 2 trustees for this person? So in a situation like that, it's not strictly necessary, but it's highly advisable to appoint a trustee to hold the property in trust until the minor turns 18. It is usual practice to put a trust provision in the will so that the executor knows to hold the minor share in trust and to keep the relevant assets properly on behalf of the minor child. Some parents would specifically state in their wills that a child should not receive his or her inheritance at the age of 18, but at a later stage, such as 21 when they graduate from university, or 25, when it's more likely that the child will be mature enough to handle his or her own inheritance. But it's certainly not necessary to appoint 2 trustees, and there's no legal requirement in Hong Kong for that to happen. You would perhaps want to, for a practical reason, appoint 2 trustees just for better management and oversight of the assets, but you'd want to make sure that there would be no competing interests between those 2 trustees that you appoint. So looking at another situation where we wouldn't have time in the session to go into detail about trusts and trust assets and how that is, but I can explain very briefly the concept of setting up a trust. Now, what advantages would there be to specifying how a trust should be spent, i.e., only for medical care, social care, or education, versus the discretion for the monies to be spent on anything? This is why it's important to have that will, to have estate planning in place, because you can express your wishes on how you want your money to spend, and even you can apportion it. So it would be particularly helpful when you're concerned about how your children will manage financially after your death. Being specific in your plans provides certainty. It ensures that your intentions are clearly communicated. It can also protect your children and the beneficiaries from mismanagement of your estate or overspending, ensuring that the trust lasts longer and for the benefit of your children. So looking forward, some of the other issues to consider when setting up of a will. Liquidity during probate, we touched upon briefly about trusts. What about insurance? It is important to set out a list of assets. It's not required, but it is helpful. The list of assets just makes it easier to identify your assets. For example, if you do hold significantly complex assets and a number of investment accounts, which may not necessarily just be in Hong Kong, but globally as well. You could be as detailed as putting down your context of your relationship manager, identifying accounts. It just makes it easier for the management of your estate and for the executor to follow through. The location of your will and any estate planning documents is really important. Please do not put your original will in your safe deposit box. When you pass away, the banks are automatically notified of your death and they freeze your assets. Your bank accounts can be accessed once you have probated the will. And you cannot probate the will if the will is stuck in the safe deposit box and has been frozen by the bank. So, and for probate to happen in Hong Kong, you do need to produce the original will. A copy is not sufficient. So you have to make sure the will is kept in a safe place. If it's in a safe deposit box at home, if it's kept with the executor or kept with the lawyer who helped you draft the will. What happens is upon your will, upon your passing, if the will cannot be located, there is a system in Hong Kong where your name, the deceased person, the name will be broadcasted in the Law Society Gazette, and it will be sent out to all law firms to check whether they may be holding your will if it's not been made clear who prepared the will for you. So these little practical tips it's just something to keep in mind and just to make the whole estate planning process as smooth as possible. So once you have prepared your will, do ensure that it remains valid and it's appropriate. Keep in mind that as years go by, you might want to look to update the will. If you plan to marry in future, keep in mind that divorce or marriage revokes a will or part of a will, so you might have to update at that stage. Are there any change in personal circumstances, your own or within your family unit, which may require you to have updates? And then there could be changes in the law, in which case your lawyer or the person who assisted you to draft the will would inform you. You could also keep with your will a letter of wishes. We have done a few letter of wishes for parents with children of SEN, where they write letters to their children and they have that annexed to the will. They also, the letter of wishes could be written to the guardian of the child. So that's something that you could do. And keep in mind that you don't have to redraft the entire will if you have minor changes to it. You could just do it by way of a codicil, which is a short updating document. So would you have one will or would you have several wills? What's the best thing to do? And of course, at the time of preparing your will, whoever's assisting you with that would give you the advice. There are advantages to both. And it very much depends. It's on a case-by-case basis. And the question would be addressed depending on your estate planning choice, and it would be dependent on the nature and the type of assets that you hold. So in terms of one or several wills, certain jurisdictions have a mutual recognition for a probate procedure. Hong Kong and the UK, for example, follow common law. So it would be seen to be a more seamless process. So if you get a grant of representation in one jurisdiction, it may be resealed in another country under a relatively simplified procedure without the need to take out a fresh grant and an entire application in that jurisdiction. But for individuals with assets in Hong Kong and the UK, a Hong Kong will can simply be resealed in the UK. So it's a quite simple process. So the way it works, a will would have to be probated in each jurisdiction. And it could be quite long. It could take a longer process. What would happen is the executor would see that the Hong Kong executor may not know that you have a will in another jurisdiction. So it would only put the Hong Kong will to probate, which means until your lawyer in the other jurisdiction or the executor in the other jurisdiction has been notified, only then would they then deal with those assets in those countries. Now, having several local wills, the will can be probated in that jurisdiction. Again, it could take long for the notification to happen. And the advantages and disadvantage of that, it is on a case-by-case basis, but you do have to make sure that if you do have more than one will, and whoever is advising you should inform you that you have to make reference to the other will. Otherwise, you could immediately revoke your Hong Kong will. For example, if you have a will in Australia that's already in place, and then you subsequently do a Hong Kong will just to deal with the Hong Kong assets, but you make no reference to the Australian will, by signing the later will in Hong Kong, you would automatically revoke the Australian will if there's no mention of that will. So just keep that in mind. So if you have one will, any liability of the estate will be borne by global assets. So all the costs associated with putting your will to probate, etc., will be paid from your assets. And then with local wills in other jurisdictions, the executors would only have the responsibility for the estate in that local jurisdiction. So whoever is the executor of your Australian will, for example, would not have jurisdiction to put your Hong Kong will to probate. But usually in a situation when you're doing global estate planning, you want to make sure that there is it's all made very clear. You've disclosed where you've done estate planning in other jurisdictions so that it makes the process seamless in future. Now we'll move on to a next topic, but before we go on to that, just briefly, what happens if a child is over 18 and is considered a legal adult and they sign documents or are coerced into marriage? They may borrow money, example, they might not be financially prudent. What can be done to prevent this? You would want to have in place an enduring power of attorney, and this has become an extremely common document in Hong Kong. This is quite different to a general power of attorney. A general power of attorney is you would appoint attorney to deal with all your general financial affairs, whereas an enduring power of attorney is more form specific, and you would need to comply with the criteria of the EPA form in order for it to be a valid document here in Hong Kong. So looking at the enduring power of attorney, it gives the person, the attorney that you have appointed, the power to deal with your financial affairs. And you can make that as specific as you want it to be. So you can tailor it. Now, the choice of attorney has to be someone who's attained the age of 18, so an adult, should not be someone who's been made bankrupt, and has to be mentally capable. So this document ceases to be effective if the donor becomes mentally incapacitated. So in order to have an EPA signed, you would need to have a doctor sign off that you are of mentally sound mind and capacity when you're signing this document, and it would also need to be signed by a lawyer. So there are signing requirements to make this document a valid document. Now, the authority of the attorney, as I mentioned, when you can tailor it, there can be an express limitation to how they can act expressly to your wishes. For example, handling your property and financial affairs in Hong Kong, acting under the EPA to maintain the donor or prevent loss to the estate, and to use the money to pay the attorney and the dependents of the donor to meet expected needs. So you would have this document in place to ensure that if you have, for example, an adult child who's suffering from any form of SEN, who you feel is, even if they benefit from your estate, how are they going to run their financial affairs? This trusted attorney who you've appointed would assist with that process. So it would allow them to have powers to use assets in your bank accounts to your benefit and to look after your dependents. And you can specifically state how you want those dependents to be looked after. And this also avoids an expensive and distressing court proceeding, very much the same way as having a will in place. You'd be surprised at how much probate litigation is still happening in the courts. And probate litigation takes a very, very long time. And that is something you would want to avoid, particularly if you have a child with SEN, because you would want them to be able to have access to your funds in order to, as I mentioned at the outset, so there's no disruption to their life. Their routine, the stability in their life can continue. That's really important. Just very briefly, apart from the EPA, there is another document, which is a living will and a medical advance directive. The only reason I want to touch upon this document is what happens if you have not passed away yet and you have a child suffering from SEN and you're not able to make any decisions concerning your own medical care whilst you're alive. And if you have a adult child who's suffering from SEN, they may not be the right person to make that medical decision on your behalf. So you might want to appoint somebody else. This is why the advance directive is referred to as a living will, because you're still alive, but you have somebody else making the decision on your behalf. So it basically means if you are incapacitated and can't make decisions, you would have somebody who's of sound mind and capacity that you have appointed to make decisions on your behalf about, for example, life-sustaining treatment, if you end up being terminally ill, if you are unfortunately in a persistent vegetative state or state of irreversible coma or other end-stage or irreversible life-limiting conditions, you would have this person make the medical decision on your behalf. This is a very morbid document because you're obviously thinking about you're appointing somebody to make a crucial medical decision on your behalf, but it's just something you can't ignore. We don't know, we don't have a crystal ball. We don't know how things are going to be in future. So as much as you can do to reduce the unknown in future, just know that this is another option. And just very briefly on the enduring power of attorney, I just wanted to flag that the EPA is a form-specific document to Hong Kong only. So the EPA or whoever has the power of attorney would not be able to deal with the same powers relating to your finances in overseas jurisdictions. It would only relate to assets in Hong Kong. So for example, if you did have assets in Singapore, or you had a majority of cash in bank there, investments in Singapore, you would have to put in place the same document, which is what you call a lasting powers of attorney. So moving on to the topic of who is a guardian. And for what we've discussed today, of course, that is important to all parents. What's going to happen to my minor children should something happen to me? And for that reason, also, what's going to happen to my adult children who you feel still will need an adult or a guardian as a dependent person in their adulthood life. So the general understanding is that such a person acts as a parent substitute and arguably should have the same rights and authority as a parent. So again, many reasons for appointing guardians in Hong Kong. How would you appoint, who would you think would be the most appropriate person? Now, as I mentioned earlier, there's the interim guardian and then there's a permanent guardian. Hong Kong being a very transient city, people have come to Hong Kong for a temporary period of time to work, and then this may not be their permanent home base. They may appoint their children's permanent guardians in overseas jurisdictions. They may be the siblings of one of the parent, an uncle or aunt, could be a grandparent. And it's important for parents to have this discussion, because if something were to happen to you, you don't want both sides of the family to be fighting over your children. The children could have a close relationship to both sides, but it's important to identify who the guardians are going to be. And it's really important not to separate the siblings. So appointment is needed to ensure someone takes legal responsibility for your child. If they're under the age of 18, should you pass away. Of course, if it's only one parent that passes away, automatically the surviving parent would have the custodial rights and the right of guardianship to make decisions for a child. If you do not have a guardianship wish document, whether it's by way of a guardianship deed or it's not expressed in your will, then your child will become a ward of the Hong Kong court. So the family court in Hong Kong will take jurisdiction over your child. Now, this could be particularly difficult for a child with SEN, because they would be put in the hands of the social welfare department. They would, if no one steps in automatically, they may be put in temporary accommodation. They prefer familiarity. They like their surroundings. They don't want to be living in a dormitory with other children. They don't want to be in the hands of somebody that they don't know. So it's not the most ideal situation, of course. So having guardianship wishes in place is important. Now, the deed of guardianship, it's not a complicated document to have in place. You would set out the details of the parents, where you're living. You would set out the full names of your children. You would want to identify them by passport and ID card. You would then set out who you want the interim Hong Kong guardians to be. Ideally, these should be people whom the children are familiar with. It can be a neighbor who has stepped in to look after the children, who the children knows well. Who it could be a close family friend. It could be a relative who lives in Hong Kong. And then you would state in the guardianship deed that you intend for this interim guardian to look after your child until the permanent guardian comes to Hong Kong to collect the children and remove them. Now, you would also want to ensure your will states who your permanent guardians are. Now, we did a lot of deed of guardianships during COVID, as some of you on this webinar might be aware, where a lot of parents and children were separated in hospitals and all the temporary accommodation that was set up. A lot of the deed of guardianships were produced to medical staff and hospital staff to allow visitations for guardians to come and drop off food, to come and drop off toys. Keep in mind that even though we're very blessed in a place like Hong Kong to have our domestic helpers, who we treat as family, in the eyes of the Hong Kong law, they are not the legal guardians of your children. So they could be one of the temporary guardians until one of the permanent guardians come. And you could expressly state in the guardianship deed that you would like the children to remain living in their home, in their accommodation, until the permanent guardians come to collect them. So what happens if, can a will or a guardianship plan made in Hong Kong be transferred to another country? Now, I explored that concept in terms of the permanent guardian coming to remove your child. Who's the trustworthy executor, or if you were to have a trust and not a guardianship deed, that really depends on your situation, and there are definitely professionals who can step in to assist with that process, or even a lawyer. And what happens if a child moves overseas to a common law jurisdiction? So under the Guardianship Minors Ordinance in Hong Kong, the appointed guardian can assume parental rights and authority automatically upon passing of the parents, and therefore can remove the children from Hong Kong without the need to obtain special permission. However, with the deed of guardianship, where the express wishes of the parents are given, it is as simple as an application to the court to notify the court that the child does not need to become a ward of the court and that they should be the child's legal guardian, and they should be the one to take on the role as the custodial parent. Now, it's in a situation like this, we've had a number of situations where parents have not expressly stated who the guardians should be. We've had grandparents apply to the court to become the children's permanent guardian, and there have been competing interests. And sometimes that happens because, of course, there could be financial incentive to want to apply to become the children's guardian. If, for example, you know that your brother or sister who passed away had significant assets, left behind a very large estate, you might want to put your hand up and say, I'm the appropriate guardian. I want to look after the children, without even that person having the best interest of that child in mind, particularly a child with SENS, because there's a monetary incentive there. So appointing your child's guardian is really important. Now, if you have a child who's over the age of 18, it's still possible to appoint a guardian through the Guardianship Board in Hong Kong. This falls under the Mental Health Ordinance. And for example, autism falls under a mental disorder because it's considered a disorder or a disability of the mind. So it is still under the Mental Health Ordinance. There is a Guardianship Board which acts as a quasi-judicial tribunal that would appoint a guardian for a mentally incapacitated person. So through that board, it is possible for the following to be done by the guardian: to manage finances, to ensure access to necessary services and medical treatment, and to protect them from abuse, from exploitation and neglect, and to ensure that their overall quality of care is enhanced or at the very least maintained. So it is possible through the Guardianship Board to appoint a private guardian, and this could be a family member or a friend, and this is what the parents would prefer. And in the absence of that, it would be a public guardian who would be the Director of Social Welfare. Now, while of course the Director of Social Welfare would keep in mind the usual principles concerning children in Hong Kong, i.e. making decisions which are in the paramount consideration of the child, even if it's an adult child, it may or may not be the decision that the parents wanted for their child. At the end of the slide, I've made a comment about difference between married and unmarried parents. There is definitely a difference. If you are unmarried, but you do have a child, the mother has the custodial rights and the father would need to apply to the court under the Guardianship and Minors Ordinance to have custodial rights of the child. And there's a process for that. So when I mentioned up here, when one parent passes away, the other parent gets automatic rights of guardianship. The guardianship rights are correct, but the custodial rights of a non-married couple are slightly different, where the father actually has to apply for it first. So what do you need to prepare? You would need to look at your personal information, have that ready, passports, Hong Kong ID cards. Look at your financial documents, bank statements. Always important to have a list of assets ready, and this is not necessarily Hong Kong specific, so this is globally. The more detailed you are and can provide information at the time of doing the estate planning, the better advice you will receive on your global estate planning needs. And then your advice will be given about whether a will, one will or more than one will, whether it would be helpful to put in place a trust and what type of trust and the structure of the trust, setting up of the guardianship document. Really do consider how many layers you might want. Don't make it too complicated. If for example, you have one interim guardian in Hong Kong, what if that person is traveling when something happens to you? Maybe have a second or third layer. You could have 2 layers and say at all times you would want your domestic helper to remain in the home with the children. So there is some consistency there if they're living in Hong Kong when something happens to you. And look at the special considerations, what we touched upon at the outset of the seminar. Look at the special needs or requirements for the child that may require you to pay extra attention to. And what are the specific wishes and concerns of your child or your children? It would not be advisable to have in place a permanent guardian or even a temporary guardian of somebody who's not familiar to your child. And then make sure you set out your clear objectives on what you hope to achieve in the estate planning meeting. So that is the end of what I wanted to share. But of course, if you had any questions, I would be happy to answer them.
Okay. Thank you so much, Anisha, for sharing your invaluable insights with us today. I see that we actually have questions. With will and without a will the estate go into probate?
So if you have a will, only then it will go into probate. So without a will, it would automatically fall into the intestate's ordinance. So if you have a surviving spouse and you do not have a will in place, then you would go to the registry and notify them, but the process of the intestacy process would take place. And that would be more difficult if, for example, you haven't even set in place a list of your assets, for example. So you don't have a will and you haven't even set up what your full list of assets are. It just makes it a more complicated process. So the only difference is if you want a different order than the intestacy order. Yes, more or less that's correct. But then also, depending on the hierarchy that I explained, for example, spouse with children, no children, whoever is surviving you, it's also the amounts. So if you would want them to receive more than that allocated amount and you have more complex assets, then yes, it's a little bit more than just not complying with the intestacy arrangements. Presumably with a will, you go into probate, there is a cost to probate, 4% of the entire estate. Well, it depends on if you're going to the executor of your estate. If you're probating on their own, the executor takes on the bulk of the costs and negotiates. I think you're probably looking at around that amount. But then, of course, if you're going to a law firm to assist with the probate process, which for a more complex estate would be advisable because there's a lot of moving parts, then you would the additional legal costs would come up from the estate as well. If I have a permanent guardian and a temporary Hong Kong one, which documents does the permanent guardian have to have? A proper legal document from a relevant jurisdiction. So the deed of guardianships that we do, we sign them in multiple copies. So we have make sure that all the interim guardians have a copy and the permanent guardians have a copy. And the permanent guardians need to be notified that the parents have intended that should something happen to them, they want their children to live with them. And to be notified that they've also been mentioned in their will as a permanent guardian. Now, if the permanent guardians reside in an overseas jurisdiction, you don't need to have an alternative document. The permanent guardian would need to deal with any legal documents once the children are with them in that jurisdiction. So as long as leave has been granted by the Hong Kong courts for the children to be removed from Hong Kong per the express wishes of the parent, it shouldn't be an issue. Pre-EPA is diagnosis of autism spectrum disorder or ADHD sufficient for a doctor to sign up that child adult needs an EPA? No. So this would be for the parent, not the adult child, because you would have to be of unsound. They would have to say that you're of unsound mind and capacity. So the threshold is higher, actually. Are payments on death for bank accounts available or transfer on death available for my significant brokerage account so they can avoid probate? Payments on death. So I think it would really depend on the sort of the company or the bank where you're holding your accounts. Usually, there would be some transaction fees. For example, we've seen some investment accounts where there are penalty clauses if you have to take out funds earlier than when they should be realized. So then that would come out of the overall estate costs, or the brokerage account the company handling it would deduct those fees before making the payout. Is it good to have trust together with will for planning? Yes, we often do both, but I think, again, very much case by case, and it depends where your assets are. What is the purpose of setting up a trust? Is it an education trust? Is it a trust specifically for medical needs? That would be obviously in addition to having your will in place, which would clearly deal with your assets upon your passing. So how long does probate take until I can access my spouse's assets? That is very much a golden question. No idea. It, again, depends how complex your estate is. If it's quite straightforward, say a couple of bank accounts in HSBC and one property, assets that are very easily identified. And the reason why I mentioned that some executors work with lawyers is if the probate documents, the documents you file, the actual application you make to the probate registry is not drafted properly, it could take a very long time because the probate registry is very pedantic and they could come back with a number of requisitions that would delay the whole process. If in the will, I ask the executor, guardian, trustee to distribute the asset to my children when they become, say, 25, can my children, when they become adult, end such arrangement? Sorry, do you mean when they, whoever asked that question, do you mean when you turn 18? In terms of ending that arrangement, the executors would comply with whatever is stated in the will, unless an application is made to challenge the either the validity or the contents of the will. So, for example, if they turn 18 and they want their money right away, it would be at the executor's discretion, first of all. Otherwise, the executors will do everything to comply with your wishes. So if you wanted to put a discretion clause in your will, that's possible, but you just have to be a little careful with that. I heard that setting a trust in Hong Kong is prohibitively expensive, with minimum starting cost of 250,000. Is that the general ballpark? No. I'm not sure what that trust was for, but again, as I mentioned, it depends on the purpose of the trust. If it's a discretionary trust for a specific purpose, then no. But the reason why people automatically assume that setting up a trust is expensive is, of course, you have the administrator's fees and the trustee's fees. So it depends who who the professionals are, or whether the trustee is a professional. So you have those fees in addition. So there was a suggestion that it can make sense for one family member and one professional law firm to be appointed as executors. In this circumstance, is it typical to specify a hierarchy between the two executors, or are they generally required to act jointly? Is there a best practice? Yes, better to specify. We've seen a range. It could be the law firm working jointly with the family member, so the professional working jointly with the family member, or you could specify a specific person in a law firm, for example, if it's a partner or a lawyer that you trust, and in the absence, if that lawyer is no longer around or there in the absence, then it would be the family member. So the hierarchy is, it's suggested, is preferred.
There is a question coming from Eve, and the question is, do we need the guardian deed to be notarized or drawn up with the help of a lawyer, or can we just sign it ourselves?
Always advisable to get legal advice on it, just to make sure you cover everything and it's structured properly. To be signed as a deed, and the signing requirements for that would need to be complied with. So you would need to seal it with the sealing stickers for a deed, and you would have to get 2 witnesses to sign the deed as well. So of course, if it's something as with a will, if you would prefer to do your own will and do the signing requirements without a lawyer, you could.
So one final question, or there two, yes, two final questions, and then we'll have to unfortunately wrap up. Can you see the
Sure.
question?
Yes.
The last
Home
two.
insurance policies and joint ownerships avoid probate. Are there any other strategies? I'm not sure what those other strategies are, but those are generally, I flag those two because they tend to fall out of the probate and the will process. Of course, joint bank accounts and joint investment accounts. For example, if your parents are elderly, you are you think that circumstances suggest that something may happen, you would want to ensure any sole bank accounts your spouse or partner is added on, so that should something happen to you, they can literally go to the ATM machine and withdraw funds. Because as I mentioned, as soon as banks are notified of your death, your assets are frozen. So any ways that you can add on somebody to be able to access your funds, of course, that's an added advantage.
One final question.
Sure. Who can help with ethical wills? I assume are you talking about in Hong Kong, that's the advanced directive that I mentioned, who would make those decisions on your behalf. You, again, with that, you have to be, a lawyer would need to sign up on the document, or at least a witness, and you would need to have a medical practitioner. You would have to go for an appointment and make sure that you are of sound mind and capacity when you're signing off that document. The only thing with the advanced directive, it is very, very form specific. Whereas an EPA, you could be a little bit more creative. The advanced directive form, you could actually download it from the hospital authority website, and you can't really deviate. It's a tick boxing exercise.
There is one question that just come in, but this will have to be the final question. Anisha?
Yeah. Oh, I saw that. The question from Steph. You are right. I mean, they're not automatically notified. What I mean is, if they are informed of your death, they would obviously freeze your accounts. But at the end of the day, people still have accounts, not always in joint names and sole names. So those accounts, you would still have to wait for a will to be probated to have any of the funds in those bank accounts or investment accounts released.
Okay, so I'm very mindful of the time, and thank you so much, Anisha, for this extremely informative question. We've actually crammed in quite a lot, and I'm actually very happy to see such an animated group of parents. So unfortunately, we have to wrap up today's session. This webinar is actually recorded, so we'll be able to send you the link later. And of course, you're more than welcome to reach out to Anisha and her team afterwards for any follow-up. As we wrap up today's session, I just want to say thank you to everyone. Thank you especially to Anisha. Thank you so much to all the co-organizers today. Thank you, Withers Hong Kong, for your time. Hopefully we could collaborate soon for future webinar sessions. Thank you, everyone.
Thanks, everyone.